Welcome to a special edition of Off the Clock. Recently, there have been 3 major employment law-related regulations drafted by the federal government. We are quickly recording 3 episodes, 1 on each regulation, to make sure you are up to speed as quickly as possible and have your takeaways about what you and your organizations need to do next. On this episode of Off the Clock, we're going to talk about the new regulation that bans non-competes nationwide.
Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
This may be the most anticipated, right, of the new regulations that were all announced within a week. Right? We have talked about it previously, the proposed regulation. We're talking about it again now because the final regulation with an enforcement date has been issued.
That's exactly right.
Right?
Yep.
Right. So as with all of these episodes of the new regulations, we're going to talk about what it is, if there's litigation, and if it will matter to you.
And what to do.
And just what to do about it now.
That's right.
So can you give us the nuts and bolts of the rule?
So the rule does ban all non-competes, okay, for that are used by for-profit businesses.
Oh,
okay. There is
interesting.
Just a little nugget there.
Yeah.
Interesting fact: the FTC doesn't have jurisdiction over certain nonprofit organizations. Okay, so that is why it's different. Okay, I'm not going to get in the weeds in that, except to say the FTC's position is it's not as simple as saying you're a 501c3. Okay, the analysis is more complicated than that. Okay, so
Lord.
for nonprofit organizations, I'm thinking particularly of healthcare organizations.
Exactly what I was going to ask you
It's going to be really important to get a specific analysis as to whether this applies to them or not. Okay, all right. So
Got it.
It bans non-competes. There is an exception for non-competes that are obtained as part of the sale of a business.
Okay.
Okay, and there is an interesting exception for certain executive employees who already have non-competes in place when this law becomes effective. Those non-competes can continue, and the employer could seek to enforce them.
So that is an interesting change from the proposed rule, right? Which we have discussed at length and others have discussed at length. Why should people not get too excited about this acceptance here? Because I think a lot of people are really going to try to hang their hat on that.
Yes. So the FTC did define who's a senior executive broadly. First, there's a salary requirement. This is feeling like a little like the Fair Labor Standards Act. I was picturing an FTC individual having lunch with somebody from the Department of Labor and figuring this out. But anyway, the compensation threshold is just over $150,000. Okay. That's not significant for a senior executive. It's the duties part of it that really is narrow, and it
very narrow.
Applies only to the president, the chief executive officer, or the equivalent, and others who have policy-making authority that really is at the same level as those individuals. So we are talking about the C-suite. Really, for me, the most important takeaway is who we're clearly not talking about for the most part, and those are sales employees, right? Unless we have somebody who's in the C-suite who's overseeing all sales of the organization, that exception is not going to apply to your boots on the ground sales reps. Those are the individuals that
we often care about the most, right?
Yeah, almost all of the non-compete litigation that I've been involved in has involved sales folks, so it doesn't apply to them.
Interesting. And I'll just note, this definition of executive is different than the Fair Labor Standards definition of an exempt executive employee.
Of course.
So don't be confused. Of course, it is confusing. We're just the messengers, though, right? We didn't create that situation. I think the takeaway there is it's narrow.
It's very narrow.
It's very narrow.
And again,
very few of your employees are going to fit into that
right.
exception.
And I want to
is the
say this
takeaway.
again so that there's no misunderstanding. Even for your employees who fall within the definition of senior executive, that only means that the existing non-competes can remain, okay? The rule still bans employers from getting non-competes or trying to enforce non-competes that have been obtained from those people after this law becomes effective. Which, of course, begs the next question is, when is this law going to be effective?
When is it effective?
It's effective 120 days from when it's published in the Federal Register. That should occur very soon. So roughly
What's the
speaking, I'd
estimate?
say near the end of August,
Okay.
it'll
Got it.
become effective.
So near the end of August, even your C-suite executives who are hired, you're not going to be able to have if this rule stands,
If
you're not
this
going
rule
to you're not going to have an enforceable non-compete with them.
Yes.
Got it.
Now, I just want to say one more piece about the rule that I think it's important for people to pay attention to is how it defines what a non-compete is, okay?
To me, that's the crux of the whole
Because that's going to be important, and it's
Yeah.
interesting.
Because if we just have to rename some contracts, Sarah.
Yes. First of all,
We're good.
it means a term or condition of employment. So first of all, it's something specific to employment. It has to be an agreement that a business is making an individual sign as part of employment, as distinguished, for example, from maybe a deferred comp benefit, right? Or we often, a profit sharing opportunity, et cetera.
Shareholder
Okay,
agreements might be
shareholder
another
agreement,
example.
ESOPs, et cetera, okay? There is probably an opportunity to distinguish those types of agreements with good verbiage that lawyers have written so that it avoids the definition of non-compete under this rule, okay?
Got it.
And it has to, a non-compete has to prevent or function to prevent an individual from working for a business at all, completely. Okay, so again, carefully crafted confidentiality clauses, non-solicitation clauses, likely could pass muster under this rule as well.
Got it. Perfect. That's offering some optimism.
Yeah, thank
to
you.
some folks,
I thought I
right?
would just insert a little optimism.
Yes, that's good news.
All right, so the $1 million question, right? Is it going to be challenged?
The litigation question.
Yes.
By the way, pre-COVID, did we ever include litigation when we were talking about new laws or regulations? It was just never part of the initial conversation.
We just
but-
assumed that it would happen.
Right, but now we have to talk about, because that's always one of the first questions
Yes.
people ask us whenever a new
Yeah.
regulation and specific comes out. So what have you heard?
There has already been, the answer is yes.
Yeah,
In Texas, of course, right?
what a shock.
Yes, right. And so no question, litigation will be filed challenging this rule. My legal opinion is that I think it will be difficult for the FTC to survive those legal challenges, to be honest. This is a very, very broad exercise of an executive agency's power.
I agree.
And so ultimately, right, if we're looking at the long game, okay, it could very well be the case that the US Supreme Court eventually says that this is unconstitutional and can't stand.
Yeah.
The struggle, of course, for our listeners is, what about in the meantime?
Right, because you don't end up in the Supreme Court the day after filing a
No,
lawsuit. Right?
exactly. What about in the meantime? And then, again, that will depend on whether a federal judge or federal judges issues a stay that applies to our listener, that applies to your particular business. And that, for this rule, could very well be the case.
That a stay could be a stay. In other words, the FTC will be ordered not to enforce the new rule. That's what the stay would be.
It could be nationwide. It's going to depend on the litigation, it's going to depend on who the plaintiffs are in the litigation, et cetera. That we don't want to get in the weeds, but that whole concept of how broadly these federal judges can issue those stays is also a legal issue that's in flux right now. So yes.
So we just want people, this can become a very complicated conversation.
Yes.
But the takeaway on that is, just because you hear news that litigation was successful or a stay was issued, you have to get to the next question, which does it apply to me and my organization?
That's right.
Yep.
That's right. Okay. I forgot something important about what the law requires.
Oh.
For your non-executives,
Yeah.
non-competes are banned altogether. Okay.
Yeah.
And there is a requirement to issue a notice to them, to any employee with whom you have a non-compete.
Okay.
That contains certain information, including, of course, the fact that their non-compete is no longer enforceable and it will not be enforced.
That is all super helpful. So now we kind of level set on what the rule actually does. What do organizations do now? Right? What do they need to do? What do people need to talk about other business leaders about what to do?
Right.
What are you telling people?
If it were my business, I quite frankly would be waiting until much closer to the effective date to be making decisions on this.
I certainly wouldn't be issuing any notices right now.
I certainly would not
Yeah,
be
that's-
issuing any notices.
That's an easy decision.
That's exactly right.
Wait until you absolutely have to, and then make the decision.
Right, exactly. If we're hiring employees, new employees, between now and the effective date, and we're not quite sure, right, whether these rules might ban a non-compete that we're asking them to sign, that may be an interesting point of conversation among leaders. And I would expect the candidate is probably also going to push back after hearing about this on the news with regard to the non-compete. Does that make sense?
It absolutely does.
On that note, I have already had clients tell me employees are asking about this.
About their own non-competes?
Yes.
Whether they're enforceable?
What are you going to do about does this mean my non-compete is not enforceable, et cetera? So
Interesting.
the one thing that I would think about doing in the meantime is considering, is maybe putting together some talking points for those questions as they come in.
Yes.
And maybe telling leaders that if they're getting asked those questions, direct them to a particular point person, probably HR.
Yeah, cascading that information from the top down. I don't know, I'm a big fan of communication early and often. I don't know here if I'd make a general pronouncement across the organization, but I love the idea of having talking points that all the leaders can rely on.
Yep, I agree.
Which end with, talk to so-and-so in HR.
Right, yep.
But also the talking points are, we're aware of the new law. It's a little more complicated than it might appear. Of course, we're going to comply with the law. We're not sure what that means right now, though. Go talk to so-and-so about your own.
And then in terms of the only other thing I can think of is if it's an organization that could fall under that nonprofit exception, they might want to dig into that to have that answer. So that they know one way or another and can stop paying attention to the legal challenges and wondering how they impact them. Because if the FTC does not have jurisdiction over you, then you don't have to worry about it anyway.
And one final point, I know we talked about this in our shows, other shows about this, but this is also a good time, if you haven't done it already, to talk with senior leadership about, do you really want non-compete?
Right.
And do you want to be out of this back and forth on the law and do a non-solicit confidentiality agreement instead? And just give up on the non-compete concept so you don't have to worry about any of this.
Remember, this is just one part of a rising tide.
Yeah.
Right? This feels like the end of the world. But I was reading an online chat among lawyers this morning, and one of them said, "Welcome to California," right? So
It is possible, you mean, to exist without non-compete?
Even if this FTC rule goes away, the continuing challenges to enforcing non-compete agreements are not going to. And we're going to continue to see states banning them. We're going to continue to see an effort against enforcing them, et cetera, et cetera, et cetera. So also a good reminder that there are lots of options to protect your business's proprietary information and trade secrets and competitive interests.
So if folks remember just a few things from this episode, the FTC issued the final rule. There was a proposed rule earlier. Now there is a final rule. It is being challenged. We don't know how that is going to end up. In the meantime, because non-competes are going to be banned for everyone except current high-level executive agreements, start making plans on how you're going to deal with that if you want to discontinue the use of non-competes altogether.
Right. All right.
Okay,
Thanks,
thank you,
Rebecca.
Sarah.